Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello, everyone. This is Anish Vashista, and you're listening to Immigration Talk with Attorney Anish. It is March 22nd, 2019, and we are right at the stage when, if you haven't started the H-1B process yet for the fiscal year 2020 cap, then you should be panicking. But it's still not too late. You can start now. However, there are a couple of steps that you need to complete before you're ready to file. Your hard deadline is April 5th, 2019. That means that USCIS must receive the petition by that date. Otherwise, it's not going to qualify for the lottery. And yes, there is a lottery this year, and you will only be in the lottery if you submit the paper petition with USCIS by April 5th, 2019. Do not send it so that they receive it before the first business day of April, which is April 1st. And that's not an April Fool's joke. That is the first business day of April, April 1st. And during that whole entire week, the first 5 business days of April 1st, 2nd, 3rd, 4th, and 5th, USCIS will accept for the lottery all fiscal year 2020 cap petitions submitted to it on paper and received by them on those dates. If they receive it before those dates or they receive it after those dates, no chance. There are some rare exceptions, but that's only if there was some kind of error and you resubmit with the request that the error be rectified. Very rare for that to actually work. Anyway, before you can submit and have filed the H-1B petition, there are a couple of steps that we're going to go through and that are very, very important. But a couple of things. I know some people have been hearing a lot about how the USCIS, that's the United States Citizenship and Immigration Services, a component of the United States Department of Homeland Security, is changing up the way it does its lottery, especially because there's not much transparency in the lottery process. It tends to favor those who have a bachelor's degree rather than those who have a U.S. master's degree. And it also requires all the work to be performed up front without any promise of acceptance for filing. So I want to deal with those issues first. And it is true the H-1B process is changing, but the changes that are going into effect for this fiscal year, starting October 1st, 2019, allowing for filing 6 months before that on April 1st, the changes are not as big as all the changes that people have been hearing about. One of those changes that are going into effect is that the lottery will be done differently than it has been done in the past. Previously in the past, the U.S. Masters lottery was conducted first, and for those who were not accepted in that, they then went into the regular bachelor's degree lottery, and if they were not accepted in that, then better luck next year. This year, the bachelor's degree lottery will be conducted first. So the U.S. Masters holders will also compete in that lottery, and if they're not, and those are not accepted in that, those U.S. Masters holders not accepted in that will then be in the U.S. Masters lottery thereafter. And that is supposed to actually increase the chances for the U.S. Masters holders to be accepted in one of those lotteries. So that's good for those who have a U.S. Master's degree. It hurts the chances for those who do not. The second change, and that's the bigger change, is that rather than having to do all the work up front, the lottery is done first, and if the petitioner is selected in the lottery for that beneficiary, then the H-1B petition packet has to be prepared and submitted within a certain time frame. That change is not going into effect for this fiscal year. It is the goal for that to go into effect next year because it requires a certain type of technology on USCIS's website for people to be able to enter into the lottery and then have the lottery conducted and then have the petition packet submitted thereafter. It's a good idea. There's no guarantee it's going to go into effect next year, but the soonest it could go into effect would be next year. We are still stuck with the process this year of having to submit the paper petition, then the lottery being conducted, and if one's accepted in the lottery, then they'll get a receipt notice, and And if you're not accepted in the lottery, then everything, the entire paper packet plus the filing fee checks are sent back to the attorney or to the petitioner. So that is one thing to keep in mind, that the paper petition has to be submitted during and has to be received by USCIS during that time frame. So you can send it out on Friday, March 29th for delivery on April 1st, or you can send it out on April 4th. That's Thursday, April 4th for delivery on Friday, April 5th. Or if April 5th is not a possibility, or sending it on April 4th is not a possibility, then someone has to drive it down to whichever service center is the proper location for filing. That might be very difficult for it to be hand filed at USCIS. That we have done that in the past, especially at the California Service Center. So it is possible, but of course you only do it if it's not possible to send it out by courier service the day before. Another thing I want to talk about first is before getting to the actual process is premium processing. So premium processing, as you know, USCIS had suspended premium processing for all H-1B petitions. Then they reinstated it for those in which the employer is cap exempt, and then they reinstated it for all other H-1B petitions. Gave a separate announcement a few days ago about fiscal year 2020 cap subject H-1B petitions. Premium processing will be available for those immediately, except for those that are not requesting a change of status. The only ones that come to mind are the ones that are requesting consular processing. So those will still be able to get premium processing, but in the second phase, that premium processing is being rolled out for the 2020 fiscal year cap subject petitions. So if one wants to file or submit the H-1B petition packet for the lottery and is requesting a change of status, then the premium processing form and fee can be included with that. If the premium processing is going to be requested for H-1B petition that is going to be requesting consular processing, that's visa stamping abroad, as opposed to a change of status, then the premium processing premium processing request and fee should not be submitted with that H-1B petition, but should be submitted after the petition is confirmed to have been accepted in the lottery, and probably a little bit even later than that, probably in June is when they're going to roll out the premium process for those petitions. One thing to keep in mind, if you mistakenly send in the H-1B premium processing request for an H-1B petition that is not going to be requesting a change of status to H-1B status, but instead is requesting consular processing for H-1B visa stamping at a consular post, that's U.S. Embassy or U.S. Consulate General abroad, then that H-1B premium processing request will be rejected, and the fee for it, the $1,410 fee for it, will be rejected too. However, if only one check is submitted that includes all the amounts, the $1,410 and the regular filing fees of $460 plus the $500 anti-fraud fee plus the $750 or $1,500 ACWIA fee, there's only one check. There's no way for USCIS to separate those filing fee checks. The entire packet is going to be rejected, and it's going to be very, very tough to handle that kind of scenario. So just make sure that if you want to be on the safe side, send separate checks for each filing fee: the $1,410 premium processing fee, the $460 base filing fee, the $500 anti-fraud fee, and either the $750 or $1,500 ACWIA fee, depending on whether the employer has 25 or fewer employees or more than 25 employees. Okay, so let's go to the process that's common for all the previous fiscal years in which there was a lottery, in which there's no special rules. First thing you got to do is you have to submit the labor condition application. You have to have an approved labor condition application when submitting the H-1B petition to USCIS. The labor condition application is adjudicated by the United States Department of Labor. They have a website in which you can submit the labor condition application, and it takes about 5 to 7 business days, so about 10 days, a week and a half, for the labor condition application to be approved. So if you haven't submitted that yet, you got to submit it, like now. However, if that employer who's submitting the labor condition application has not ever submitted a labor condition application with the Department of Labor in the past, then there is a chance that the Department of Labor will not be able to match that employer's name with that employer's federal employer identification number, sometimes called an FEIN, even shorter, an EIN. An EIN is like a social security number, but for the company. If the United States Department of Labor is not able to match within its system the company's name to the company's EIN, then it's going to need some type of document from the Internal Revenue Service or from the government that shows the company's name and the company's EIN. Now, one could say, well, the company has an EIN. I'm not saying the company doesn't have an EIN. I'm saying the Department of Labor is not able to verify or match that EIN with that company name in its internal system, even though the IRS itself, which is also a part of the United States government, has given that EIN to that company. The IRS, the Internal Revenue Service, is part of the Department of Treasury. Yes, it's part of the federal government, but it's part of the Department of Treasury. The United States Department of Labor is its own agency. I know what you're saying. How could they not know? This is the system that we have to deal with. In order to get the verification required, then some type of notice or letter from the government has to be submitted to the United States Department of Labor. It can be done by email, but it's got to be sent now. The most common document that I submit for my clients is the letter from the Internal Revenue Service to the company saying, this is your EIN. That's the best document. Send that to the Department of Labor. It's a special email address in Chicago. They receive it. They match the EIN with the labor condition with the company's name, and then the labor condition application will not be rejected for a failure to match. If you don't get that necessary confirmation, you submit the labor condition application. A few days later, you might see that the labor condition application has been denied, and you're going to wonder why. You read why. The EIN doesn't match the company name. You're going to look at the EIN. You're going to look at the company name, and you're going to say, no, the EIN is right, and the company's name is right, but the Department of Labor was not able to confirm that. So then you're going to submit that letter, IRS letter, or maybe you have to call the IRS to get the letter, and you're going to submit that letter to the Department of Labor. You're going to wait for that to be approved, and then you're going to resubmit the labor condition application. By the time you get it approved, it might be too late to submit the H-1B petition packet with that approved labor condition application. So get the IRS letter, get it to the Department of Labor, start working on the labor condition application, submit that so that there's no problem. Next, in the H-1B petition process, after all that's done, then comes the real substantive work related to the H-1B petition. And there's a couple things or a few things to keep in mind. One is it's not enough just because the prospective employee has a bachelor's degree. A lot of people have a bachelor's degree, but a lot of people won't qualify for every H-1B position. I like to not focus on the beneficiary first, but focus on the position. What is required for that position to be fulfilled properly? And we have to prove that that position is for a specialty occupation. That means we have to prove that a bachelor's degree in a particular field is required to do that job. A bachelor's degree in a particular field, not just any field. That could be hard for certain occupations. It could be easy for other occupations. Doctors, lawyers, most engineers. No one's going to say that you don't need a bachelor's degree in a particular field to do those jobs. However, some other positions, it can be more complicated, especially positions that USCIS has recently taken a position on that is not stating that those positions do not automatically require a bachelor's degree in a particular field to be performed. One position that comes to mind, computer programmer. So work has to be done, and there are 4 different ways to prove it. I'm not going to go through those 4 different ways. Anyone who's looked at a specialty occupation request for evidence from USCIS knows what those four different ways are. Generally speaking, they relate to whether the Department of Labor in its Occupational Outlook Handbook has designated a certain field for that degree to verify that it's a specialty occupation. Other ways is that it's common to the industry, it's common for that specific employer, or the other employers of similar size and similar position require a bachelor's degree in a particular field be performed, or the catch-all, the last way is the description or the requirements of the job are so complicated that one cannot possibly imagine it being performed by someone who doesn't have a bachelor's degree in a particular field. So we make sure we lock down that specialty occupation understanding, while at the same time linking that to the type of degree that the prospective employee has. And if you're able to do that, then you're being pretty much 50% through the battle. The next thing we have to worry about, and this of course should all be done at the beginning before you even submit the labor condition application, is the wage level. Now, it used to be, before the current administration, that the employer had a lot of, flexibility on which wage level they wanted to select. Now, when doing the labor condition application and designate the prevailing wage, there's wage levels 1 through 4, in which one can pick which wage level that they want to have the job at. And that wage level is going to designate the prevailing wage, and the proffered wage, meaning the wage that the beneficiary is actually going to receive, it has to be at or above that prevailing wage, or the actual wage, which is a little bit technical, but that's basically about what other people in similar occupations at that employer get paid. But you don't want to pick a wage level that is above what the beneficiary is going to get paid, because that's going to automatically result in denial. So then the employer automatically thinks, well, let me just pick the lowest possible wage level. Well, that leads into another problem, where if you pick a wage level that's too low, especially if you pick wage level 1, that means it's an entry-level position. And if at the same time you're trying to describe the job in a way that to make it appear so complicated, because it is, then USCIS is going to come back and say, well, if this position is so complicated, how can it be an entry-level position? And then you lose on that. So you don't want to be stuck in this situation where you're trying to describe the job in such a complicated way to make it qualify as a specialty occupation, while also saying that you want to pay rock bottom at wage level 1 prevailing wage, or wage level 1 wage, so that you don't have to pay the employee as much. Then you get stuck into a situation where USCIS is going to deny. You want to make sure that the description of the job, while qualifying it for a specialty occupation, also is consistent with the wage level that's chosen. That kind of analysis is very important to be done up front before the labor condition application is submitted. So those are the key concepts to look at when submitting a cap subject H-1B petition, especially for the fiscal year 2020, after all the information that we've obtained from USCIS after the new administration has taken over. And I want to make sure that people do it right, and they want to move quickly now if they haven't started yet. If you have any questions, please feel free to call me. My website is www.lawfirmav.com. You can always reach me via email. My email address is consult, that's consult@lawfirmav.com. If you want to call the office to make an appointment, that's fine too. The number is 1-877-227-9714. Again, that's toll free, 877-227-9714. You can call either the LA number, which is a 323 number, also, or you can call the Fremont number, which is for the California Bay Area number, which is fine as well. There's no issue with calling either one. The LA number is 323-592-9980. Again, that's 323-592-9980. And the number for any of those always comes to the same person, so that you can be scheduled immediately for the soonest possible appointment date, whether it's for LA or Fremont. It's free for the first one in person. So again, LA is 323-592-9980. Again, that's 323-592-9980. Fremont is 510. That's area code 510-585-3990. That's 510-585-3990. It doesn't matter which one you call. You can also call the toll-free number that I gave earlier, 877-227-9714. You can email me at consult@lawfirmav.com. You can go to the website, lawfirmav.com, and submit an inquiry through the website. My point is, there's no excuse. If you want to get this H-1B done and you want to file it for the fiscal year 2020 cap, then you have to move fast, and it's no excuse if you're taking no action at this point. You got to start right now. Anyway, I hope everyone has a good weekend, and please stay safe. Thank you.